I'll just shut off and I'll restart. Okay.
So Martha, whenever you're ready, you can give us a little introduction.
It seems like I don't know what I did to myself, but let me just try it again. Allow. Launch. Do you see me?
Yeah. We can hear you. We can see you.
But I don't see you. Okay, well, I can do it without.
Yeah.
Okay, which slide is up?
The slides are not up yet. But you just, I thought you'll introduce yourself first if you want, and then I've got the slides up. I mean, we can.
Martha Montour, and I live on the Mohawk Indian Reservation, just outside of Montreal. Like I can see Montreal from my window here, and we're about a community of 7,000. And I was born, bred, and raised here. And I am a lawyer. I've been a lawyer for already over 30 years. And I trained as a mediator in 2007. And I did it through in Quebec, well, it's province of Quebec in Canada. And there's only certain professional organizations that can become trained, certified family mediators. So that way we can mediate, access the program that they have. And our clients can have about 5 hours of free service to mediate their disputes. And so that's what I did. 2007, it was quite intensive training, big commitment. And so I've been doing that ever since. And I was surprised that when I became the mediator, I mean, the clients were calling up. I was really surprised. They really needed this type of service, because otherwise all they had was adversarial. And I do other like files. So I've been in private practice. I've done litigation for the first about 20 years of my career as a lawyer in Native law, in Native American law. And the firm I was working with, we actually did a Supreme Court case that we won. It was a fishing case. And then after that, that was in 1996. So I did that. For 10 years later, I decided to do mediation, because I always liked family law, but I could not practice it in my community because there was only the adversarial system. So you have to take sides. And it's not a good idea in a small community to do that for your property and person. It gets pretty emotional. So this was an opportunity to do family law and help the couple instead of taking sides and destroying the whole family relationship. So I think I've done at least over 200 files in the community. So not all of them are successful. Some wind up in the adversarial system for different reasons. And I think they're often sorry that they didn't work harder on the mediation. So basically that's what I do. I'm still I'm supposed to be retired, but I'm still mediating because the services are still needed. And we do have a service in the community, but it's, they're not lawyers. So it's a little sometimes tricky for them to do certain files, or people don't want to use the service. So they come and see me anyway. They get like free hours if they're for mediation. So it doesn't really cost them anything. And I also do their divorces if they want. Afterward, I file it in the court. So they never have to appear in court. Then we get everything by mail, and they don't have to lose time at work and be stressed. Takes, because there's no rush when you're doing the mediation. No deadlines like they have in the court, and they don't have to pay a lawyer. I mean, they can also. I always encourage them to have the agreement reviewed by independent legal counsel, which some of them do, and then they come back, make changes. And that's it, done. Okay, so what is that good enough?
Yeah, perfect.
Okay. I was when I was listening to the previous presenter about online dispute resolution, I was busy getting ready for this, so I didn't have a chance to make a comment that I did do one. There's an Algonquin community up, it's about a couple of hours north of us, and I had to do it on Facebook, or it was online. And it was quite an experience because I guess they were still under the emotions of separating. So they were sitting together in front of their computer, and I was down here, and I thought there was going to be a fist fight between the two of them. So I got kind of like, oh, what am I going to do? I had to think fast. I guess I'll have to call the police if they really start fighting. And but it calmed down after a while. They got calm, and that was my experience with completely online mediation. So I think with online mediation, the parties would really have to trust their mediator to be comfortable with it. So, okay, that was my comment on that. Okay, so do you have the first slide up?
Yeah, I have the first slide up.
Okay, so it says, I took this I did a training seminar we have another Mohawk community, which is south of us, and it spans three jurisdictions. Part of the community, which is called Akwesasne, is in New York State, and the other half is in Canada, but it also crosses two provinces, Quebec and Ontario. So they on the U.S. side, they had a land dispute tribunal, and they wanted them to get some training in mediation. So I did a seminar with them, and this is what this is from. Okay, so the mediation in North American Indian culture, other cultures, and the justice system. So I'm going to look at that how they evolved in North America. Okay, we'll go on to the next slide.
Yeah.
Okay, so I have it categorized by pre-European contact, post-European contact, and then present-day revival of traditional dispute resolution. Okay, next slide. So in my research, what I could find, which I explained, I think in the previous seminar, Vikram, that when I was doing the research for this training seminar, I was trying to find other cultures that had the same, that had traditional dispute resolution in their culture and customs. And I couldn't find anything. I looked through the literature. So I kind of, so what I'm learning through this seminar is that the cultures all had almost the same as what we had too. So, but it disappeared for various reasons. So I'm very learning a lot. And I think when I did this research, that was back in, that would have been like 15 years ago. So I don't know if this is been documented anywhere other than this seminar. Okay. Okay. So when I did my research, I showed that I found that non-adversarial methods of dispute resolution were an integral part of Indian societies long before the Europeans came to North America. When the conflict arose, elders often acted as mediators and resolved disputes within the community. They would listen to all who wanted to speak on the matter at hand before determining what must be done. The prescribed action was always aimed at restoring balance and harmony to relationships in the community. The first priority was to keep the circle, the community, strong. And this came from the report of the Royal Commission, which would have been back in the 1990s. It was commissioned by Canada. And I just have a comment here on what I do. One of the reasons why I went into this field was to, because divorces and separations were so bitter, it's like, what do you call that? The Hatfields and McCoys when they're fighting in the community, and we're small, like it's not and we all tend to stay in our community. Always, even if we go somewhere, we return. It's always home. So if you have a breakup like that, it can get pretty bad, especially for the children. The children suffer. And I personally experienced it in my own life. And so that was one of the reasons I went into family mediation, was to at least prevent some of this. I mean, it still happens, but I figure that if we have strong families, even if the parents aren't together, then we have a strong community to be able to keep our culture alive. Okay. There was a book done by, when they implemented mediation, started to put mediation in the courts in Quebec. There was a book done by Lambert and Berube. Native communities use justice circles in accordance with their tradition and culture. So they mentioned a line in there. I guess they did a bit of research into the Native communities. But our people, the Mohawks, we belong to a confederacy made up of 5 Indian nations. There's six or seven. They have minor roles, but there's 5 nations that come together, and they made an Iroquois constitution. And they all got together to have decision-making processes on, because they were warring with other Indian nations over territory and things like that. Decision-making, there was an Iroquois constitution and it had certain steps. It was all oral. The constitution was oral, but now it's been put in writing. Was always by a caucus, consensus, and referendum. So there's articles in there that give a process for decision-making. Also, I found that the word caucus comes from an Algonquin word for tribal leader or advisor. And that is, I'm not Algonquin, so kaka, what's this? And I think it's on my, yeah, there you see it on my slide. Do you see it? I'm not sure which slide is that.
Yeah. We can see it.
Got it there. So the word is there at the beginning. And then it was modified to conquerors and then caucus. The Cheyenne chief had a duty as a peacemaker and mediator for disputes. In Eskimo, there was a religious specialist, an Angakok, and he dealt with conflict. Okay. Micmac elders, this is out on the further east of us. and I can't say that word that well either, Pixitogen, which means peaceful reconciliation and forgiveness. I'll go back to that because I'm working on a project dealing with the Algonquin. Among the Zunis, quarreling was discouraged, and a man was expected to avoid controversy. The Navajos had their own justice methods for centuries based on mediation and peacemaking. So I have all the references, Vikram. I can, the bibliography, I can send that to you. You can post it.
That'll be nice. Yeah, I think we'll circulate that. It'll be nice.
Yeah, okay. Okay, so that was, pre-European contact. Disputes were taken care of by traditional cultural methods. There were no adversarial courts built on adversarial. Okay, so we can go on to the next slide. Okay, so this is post-European contact. Okay, so our way of life, the Iroquois, of which the Iroquois Confederacy, of which my people are part of, one of the First Nations, is made up of appointed male chiefs from five First Nations, from the First Nations that were our members. There was, I'm going to jump a little bit ahead of myself. Let's jump back a bit because there were when the Europeans came over, when they first came over, it was the Quakers and there was Jewish people. Certain cultures adopted the dispute resolution of Indian societies because Europe was now all adversarial methods. And then the Quakers and Jewish communities used mediation to resolve family and commercial disputes. So in general, the traditional justice concepts of Indian societies and the adversarial systems of the Europeans were in conflict. The adversarial adjudication system was imposed on Indian societies, and traditional dispute resolution almost disappeared from the communities. They were, well, in the Mohawk society, the Europeans just made it illegal for my people to conduct traditional ceremonies, hire lawyers, get university degrees. If they did, they had to give up their status and they could no longer live in the communities. They would have to live on the outside. So they outlawed the traditional longhouse, which I'll explain a little later, modes, and also the Iroquois Confederacy. So but it never died. They were practiced in secret, like without. We had the federal government used to have Indian agents, who were non-native, watch the Indians to make sure that they didn't do their traditional practices. They wanted them to convert to their religion and not make any problems for them. Okay. And hold on a second. Yeah, everything, it was imposed through force. And I guess this was a way of getting our lands and resources without any compensation, like theft. It's the only way they could do it. And it was done through the adversarial system. And the Indians weren't allowed to hire lawyers. It was illegal, and the lawyers would get prosecuted if they worked for the Indians. That lasted till the 50s. Okay, so our traditional way of life before it was disrupted was the Iroquois Confederacy was made up of appointed male chief from all the First Nations who were members. But in each village, Iroquois matron or matriarch headed the longhouse where the extended family lived. And often, you know, there were several longhouses in the village. They would plant and have farms. The men did clear the fields and went hunting, like they would disappear. So that sort of women were left behind. They would all work together and take care of the village and the children. And okay, but she had a lot of power. She had the power to nominate and impeach their male chief if her longhouse agreed on this direction. See, there had to be a consensus in each longhouse on what to do if it was important, such as who was going to represent them at the Iroquois Confederacy. And that chief would only be allowed to voice what his long or his village wanted him to voice. He had to voice their direction. Okay, so all marriage arrangements, inheritance, and succession was headed by the female. Okay, on to the next slide. Okay, so the Iroquois elders, the matrons and matriarchs, they're the ones that acted as mediators in the longhouses. And they listened to all, or whoever was having a dispute, before coming to a solution. The goal was to restore balance and harmony to relationships and community. Okay, yeah, I already went over the Iroquois Constitution. The decision-making is always by caucus, consensus, and referendum. It was what we call the longhouse system. The longhouses were like long structures, so they could house like extended families. Okay, on to the next slide, post-European content. As I mentioned, Quakers and Jewish communities use mediation for the family and commercial disputes. And at that time, their interactions with Indian societies was very equal. You know, they were they had made a treaty called I don't know if it was verbal, it might have been verbal, what they call a covenant chain, that so they could live together since they were new here, and they had to live together in peace and harmony. Okay. So, but however, as more Europeans came over and took over the lands and resources, our traditional system, justice of Indian societies, was very much in conflict with these new Americans for lands and resources. And as I mentioned, the adversarial system was imposed through force to get to steal the lands and resources without any compensation or even partnership. Okay, so next slide, revival of traditional dispute resolution. Okay. So in my research, I looked back, and in 1939, Los Angeles had a conciliation court for family matters to assist couples to settle their issues regarding their children and minimize the negative effects on the children. In 1970, family mediation, there was justice, it was introduced to the justice systems in Britain. And there's a lady that, her name was Parkinson, I can't remember her first name, it's Lisa. She was instrumental, she published a book on it. I think it's out of print, I have a copy, I managed to find one. Very good book. 1980, family mediation in North America expanded to commercial, labor, and civil. 1984, the Navajo established the Peacemaker Court, which uses mediation and arbitration. But going back to 1980, family mediation services were established in the justice systems of North America to assist couples to settle issues regarding the breakdown of their relationship in the interest of their children. Okay, and then in 1990, here in the other Mohawk community of Akwesasne and here in Ganawage, they established Skena on Sope, an alternative dispute resolution service. And it is still in operation to this day. But as I said, they're not lawyers, or they're trained. They're trained to get general mediation training. Okay, like I said, in 2007, I became the first Native person in Quebec accredited as a family mediator, and I worked as in private practice in my community. And like I said, I was so surprised at the demand for the services in my community. And once, sometimes I'll get people from Akwesasne, and we have another Mohawk community in Oka, Ganassadage. I've gotten a few clients there now. Although they do have somebody that could train as a family mediator. I think she had started, but I'm the only one that went through with all the training, because I think she needs. I'm also a supervisor for family mediators in Quebec, so I have that capacity. I was hoping to train more Native people, but well, maybe soon. So they can service their communities. And then, in referring to Akwesasne, in 2009, they had established a land tribunal dispute, and that's where my presentation was prepared for them specifically. In 2021, the Listugush Mi'kmaq Nation, which is still in Quebec, but it's further east, close to the Maritimes. I'm involved with the Canadian Institute for Conflict Resolution, and we have we're going to train mediators in the community to take care of their disputes, and it's being funded by Justice Quebec. So apparently they're all excited about it, the Justice Quebec, because maybe we can push this program to lots of other communities. And what I see is from the seminars that I've watched so far with the Symposium, the presentations, that's what happens. They establish a community center for mediation. So that's what I foresee for this project, so they can take care of their own people. I mean, there's been other developments in North America. The American Bar Association Family Law Section has what they call use of collaborative lawyers, where they work together. Although they're representing their clients, the goal is to get a settlement out of court. And if it's unsuccessful, the parties have to hire other lawyers. They have to sign an agreement. Okay. I've also seen the term peacemaker lawyers, which is a neutral arbitrator, client representative during mediations, collaborative lawyer, unbundled lawyer for self-represented parties, where they do just specific portions of a file. And I've done that for some of my clients. Like I just prepare the paperwork for them, the court papers, and they file it themselves. They like that because it's a lot less cost than having me on the file, having my name on the court papers. But so far, everybody seemed happy with it. Transactional lawyer for relationship agreements, premarital, postmarital, cohabitation. I've had one client for that, first ever, that they, in the event of a breakup, because they were building a house, they wanted it to be settled what was going to happen. So that was something good. There's also long-term relationships for business partnership, probate, dispute, adoption, surrogate agreement. That I got that from the American Bar Association. Here in Quebec, we have what they call, we have mediation service. Like I said, they get 5 hours, but it has to be a certified family mediator. And that's what I am. There's a new development just a couple of days ago. That's why it wasn't on my list. But they have, they're going to have accredited family mediators do mediation agreements for youth protection. You know, for children having problems, and they wind up in the youth court. And I'm not sure exactly how it's going to work. They just were asking if I'd be interested, which of course I am. And so that's just a recent new development here in Quebec. And also in Quebec, most of the court rules now require that the parties be encouraged to settle their dispute by mediation or negotiations. And it's quite, in the family law area, it's automatic. Even the lawyers that don't do mediation, yes, try mediation first. And if it doesn't work, come back. So it's taken, I think when they introduced it, it was years in 1990, I think, or 1980. So it's taken that long. I'd say within the last 10 years, it's become automatic for the other lawyers, to encourage their clients to go to mediation first. And in general, the judges are pleased when a party settle their dispute by agreement, which saves the court costs and time. And the clients are happy because there's less costs. And in general, anyway, when you go to family court here, they're settling it outside the door anyway, like before they go into court, they're handwriting an agreement, and it's so fast. It's done so fast that they have a lot of issues and questions. And some things don't work, other things, you know, like they're rushing. So not everything's covered, and then they have problems, you know, with the agreement. And in my agreements, I take account into what happens in the community, because they still have to see each other. You know, they might run into each other at the local convenience store, at a wedding. And I put that in there, that they're to act civilized, you know, and not, or they're bothering each other constantly afterward about their new girlfriend, boyfriend. And I had one just recently like that. And I put in there that they're not to bother each other. They're going to be single now, and they don't owe the other one any explanation, that they have to ask permission to go to the residence, unless it's an emergency, of course, with the children. So that seems to work. So we have time, like in mediation, when I do the mediations of the agreements, we have time to work out all these issues, because sometimes one party's silent because the other party's running the show, like it's in control. And then when things get out of hand, they know they can call me and say, well, this is what's going on. She's, you know, she's giving me a lot of problems, or he's giving me a lot of problems. And then I can call them up and say, well, you know, this is not the proper way to act, and I'm going to put something in the agreement. And so it seems to settle it down. Yeah, because an agreement which both parties can live with is more likely to be upheld, as well as meet the needs and interests of the parties, their children, and their community. So that way you're not involving the police, the social workers, and because they all have enough to do. These parents or spouses have to act like adults because their children are watching them. And I'm kind of like really firm because I'm older. I can say a lot of things to these younger people. I guess I'm like the matriarch of the mediation. Okay, so the parties are more likely to be pleased with their outcome and with their lawyers, thereby paying for legal services. Okay, so I want to just give my comments on mediation with community members. There is no text or guide to mediation with community members, as the way of life differs greatly from outside our community. Adaptation and experience will be the guides, but there will be challenges. In general, the mediation training I took is based on the structure of outside Quebec life society. I find that their way of life is very transient with very small nuclear families, whereas here we're got large extended families living together, living in the same area, although not in long houses anymore, but in individual houses. Any vestiges of stable communities on the outside are rapidly disappearing as their elders age. Thus, if mediation fails to resolve disputes and recourse to adversarial resolution is done, the parties may never meet again in their everyday life. That's totally different, except for the family unit. Totally different from our way of life. Often the mediator is a complete stranger to the parties and is completely neutral and objective. Indian communities are established from traditional homelands, which provide stability for their members. Their members belong to large, extended families. Since the 1800s, their traditional dispute resolution systems were displaced by the adversarial systems of outside society. Since the 1980s, steps are now being taken to revive these practices, as the failure of the adversarial system to resolve disputes is detrimental to the harmony of our families and our community. Mediation evolved from the traditional dispute resolutions of Indian communities, and mediators are often members of the community, or they can be from another Indian community. The mediator may know the disputing parties, which is often the case for me, and their families, and may even see the parties on a daily basis. Thus, the mediator has a vested interest in the resolution of disputes for the harmony of families and community. A stranger mediator who is not from the community would have difficulty with the family and community dynamics, which are not revealed to outsiders or are misunderstood. So, okay, I think that's the end of my presentation. I also did an article, which I'll put in the bibliography that we listed, on Iroquois women's rights. When I was a student, I think I went to McGill, and my last year we had to do a paper for credits, and that was in 1987. And I did a paper in family law on Iroquois women's rights with respect to matrimonial property on Indian reserves. And that'll really show the imposition of outside law in our communities and how it's disrupted the way of life that we had, or historically. And then I submitted the paper to the Native Law Center, which publishes a law journal. And to my surprise, they published it. I couldn't believe it. I thought it was too like feminist, you know, because usually publish articles on constitutional law. So this was quite a surprise. And I guess it was good enough paper for a law journal. What else do I have to say? And some of my background too, like I have a really different background because I've always been a very independent person, like business oriented. I was also a registered nurse, and I gave that up maybe about 7 years ago. I was still working, so I had a lot of connection with my community and working really hard in the law field too with Native issues nationally. And so that's basically it. I think I'm finished.
Okay.
Question.
But Martha, the interesting thing was in the whole traditional system, when you were talking about the chain, I don't know whether I'm pronouncing it right, chain chief being the peacemaker and mediator. So, I mean, in terms of the process, was it really mediation, or were they told what to do? How did that work? I mean, something on.
Yeah, well, in the longhouse, like I said, they were made of extended families. So if there was a decision to be made, whatever it is, everyone had a say, and they worked till they came to a consensus that was to be presented or solution. So that's how it worked. It was mediation, you know. Okay. The matriarch was mediating to make sure that they all had one voice.
No, but when you spoke about I was talking about the chain chief that you spoke about. Now that chief was actually working as a mediator, you're saying?
Oh no, the chief in my society was just a representative of his village or representative, but he got his whatever decisions he made it comes from the longhouses.
Okay.
So he had to voice their decisions. And then if there was something he had to remedy, he would go back. But when on at a confederate, you know, the confederacy level or the other nations were. So he wasn't a mediator, but he was just a representative. But
this Iroquois matriarch, that concept, I think we will, when Isaac is going to present after you. So something in Ghana, he had something about, I don't know what he calls it, the Queen Mother or whatever. He'll tell us when he does the presentation. So I thought there was something similar there. So we'll talk about that when he does his presentation. So now Giovanni asks you, do these different traditions interact among them? Are you okay with the question, or you want him to clarify?
Yeah, clarify. I'm not sure what he means.
Yes, Giovanni, please just clarify your question.
Well, these traditions belong to different nations because there were not just small clans, but really different nations. And it could be interesting to know if these different cultures from different people interacted among them through the centuries, also in the present time.
Yeah, I think, well, we had a confederacy made up of different nations, so they had to interact at that level. There's other confederacies. The Micmac had a confederacy too, like of different, different communities in their area. So they definitely must have had to interact.
Okay. So Martha, the challenge you're saying right now, of course, is within the communities to bring out these traditional methods of whatever collaborative dispute resolution, whatever words they might use. But how are we going to take this to the world? That all this has happened in our communities, and now the world should see it and world should do it. Are we looking at it in a much larger context?
I think that, first of all, it took like the outside Quebec society, how long? That was 1980 to finally have mediation in their justice system. So that's how long, 80, 90 to 10. So we're going on almost 30 years, like 25 for 20 years. No,
30, more than 30 years.
it's a long time. It took a long time. And the people that introduced it really had a struggle. Like I know one of the Court of Appeal judges, well, she's retired now. Her name was Louise Otis, and we call her the mother of mediation in the court system. But it took her a long time. She had to struggle to get them to do it. I mean, so we're looking at a long development, and I think if there's more, I mean, in my own community, like I said, I was surprised how readily it was received. But I mean, there's still a big percentage of the community that think the only way to settle a dispute is in adversarial court. And well, even with labor, like I'm doing this file right now with a certain organization. I won't mention it, but he never thought mediation would be good for this dispute that they're having. But
basically,
yeah. So
the adversarial mindset is set in. So we have to change that.
Yeah, and they have to trust the mediator. Like, I mean, because I'm older to experience, I have a lot of respect. Because I don't work for any of the. I'm in private practice. I don't work for any of the political bodies. I can't because they're kind of difficult to work with. Give me a headache. Politics.
But Martha, you've been following the other sessions, or you've been watching those. Please.
I'm very pleased to learn that it's not that there was in other societies, because I couldn't find the research on it when I was preparing for the seminar. So I think one of the things that would be I don't know if it was Ken Cloke or one of your speakers from another type of session said he was putting together a book of papers from different people. Like, other people write papers and put them together in a book, and people can read it. So maybe this is something that from this seminar could be done too.
Which you are going to help me do, because some we might not have papers from, but based on their sessions, if we can bring together whatever is common between cultures all over the world, and we can do a comparative study there. I think that'll be quite interesting.
The book could just be like Malaysia, whatever is going on there. There could just be a little summary. Doesn't have to be long.
Yeah, absolutely.
Page or two,
Yeah, no, like Reza presented in the he did his session today, so he's preparing the paper. That whatever, of course, his presentation plus a paper he's presenting. So, but we get that all together, because I think people after the presentation would then be able to.
I was looking for something like that when I was doing my seminar, and there was nothing to look at other societies if they had mediation and what happened to the mediation, the dispute resolution. Like in our case, it was had to go underground because of European, the outsiders just wanted our land and resources, so they just tried to annihilate it. And I mean, they put children in residential schools to do away with their culture and language, which was terrible, but that's what happened.
No, for what you're saying and compiling all this together, that was the whole idea behind the symposium, that this is all out there, it's all been happening, and people are familiar with the process. The fact is that word they're not familiar with. You could say mediation, they might not understand what you're talking about, but the process they definitely understand. So bring that together and see it's all part of the things around us. So I think it's all there. But Martin was wanting to ask you, can I ask about political decisions? So do you want him to clarify that? Martin, do you want to go a little further?
Yeah, all the same. They did the same thing. It was all the longhouses in the village would come to a position, and then the chief would go to the Confederacy gathering and.
So hi Martha. This is Martin. Thank you very much for the presentation. I really look forward to reading a lot of the material that you've mentioned. I've read the Law of Peace. I'm sorry, I don't know the official name for it. And I was so impressed by the collaborative decision making across the nations, and the process that seemed very much like mediation that followed decisions across nations. So that was really where my query was: is how do you see that as a valid approach for communities and for nations?
Oh, I mean, that should be implemented. They're not doing it right now because they're still caught up in the old way of once you're elected, you're the boss. You know, you make the decisions, and that's it. So we don't have that system. Although the longhouse practices it, we still have longhouses, so they practice it, but they're not. We have like two systems going on right now: the old elected, imposed elected system, and we have the traditional longhouses, which do their political decisions the traditional way. Although the political system maybe might change now, we have a new Grand Chief, and she seems to be, she says that's what she wants to do. Go back to traditional decision making.
Martha, now Reza, like I told you, he had presented earlier. He has such nice things to say. He said, if all or most of speakers send their papers, maybe a comparative or review article can be published. And in the world of publishing articles, that is gold. You might even be able to publish it in Harvard or Oxford University journals. That's that's amazing if that happens. So we're getting a lot of material together and people are happy about that. Thanks, Reza. So that I think, I suppose still we really wanting to find out that, of course, the traditional methods, was there anything different, or we just use the word mediation and they were doing mediation, but was there something different in the process and how they conducted it? Was there something that you would be able to?
It's a large mediation, unless it depends on what I guess what the problem is, or what they were, or they have to make a decision on something. Then it's a large group, so it's more work. Whereas if it was just a dispute between a couple, then that's different, So it's whatever the goal was to restore, to make a decision, to present. So it's like they would consult and discuss, and what's a consensus? They provide information to the people, and then they discuss it and come up with solutions or just ideas, and then finally it comes to a consensus on one point, like one solution or one decision, and that's what the chief would take to the big meeting.
But the elders in your community, I don't know how old the elders would be right now, the eldest, but what do they remember, or are they saying changes happening there in terms of mediation?
Well, they were caught up too in when the system was almost annihilated. So they deal with that, and although some of the elders, they don't really remember. The elders now would be right in the middle of being taken over by the outside system. So they're dealing with that. So they would have to learn about traditional dispute resolution. But a lot of them know, like at the Longhouse, they have a lot of elders there, and they know about it. They read and discuss them, and they practice it. In fact, when I was first a law student, I was working here in the community, and we started discussing mediation. I thought it was a great idea. It was a new idea. That was in the 80s. Oh my God, the court, and the staff, and the police thought we were traitors. they were just trying to destroy all our work. And finally, now it's in place. I came in place later, like since 1990. In the 90s, it started to be put in place. And took a while, but but like I said, I'm still dealing with this one organization recently that didn't realize that mediation could be done for any kind of dispute, not just criminal or family or commercial, even employment grievances, and they didn't think of it that way.
So Martha, what we're going to do is, as part of the symposium, we'll have one session. On the last day, I think I would do it only on the effects of colonization on mediation in our culture and traditions, because I think I'm seeing a lot of impact that has happened all over. So I think we'll do a special session on that. I'll fix the time. So I think that should be something which is quite relevant everywhere, and how those changes happened and what really has, in terms of the psyche, the mindset, all that.
So I don't know if maybe in other societies they had it the way they did, like they killed some of the leaders in Akwesasne, the traditional leaders that were objecting to elected Indian Act system, which was federal law. So they killed them. The police, outside police, went and killed them. So I don't know, maybe this went on in other societies too.
Yeah, that's what I'm saying, that this is
I
something.
remember, I don't know if they didn't mention it in any of the presentations, but I think that's what the cause is, when they were after their land and resources.
So, perfect. So what I can do, Martha, at this point, maybe we'll end this session, so that, because we can start Isaacs, and then after Isaacs finishes, we can still continue our discussion. We can do that. So thank you very much, Martha. It was very nice. And whatever, if you have a paper or something that you put out, we'll circulate that.
I have a bibliography.
Yeah, so we can circulate that. And
the paper that I did for the law journal, I can send that to.
okay, so what I'm doing is just asking everyone to unmute. This is standard practice now. Everyone will be able to say thank you to you directly. That's the only chance they get to say anything directly.
Thank you.
Thank you very much.
Thank you, Martha. Amazing.
All the best. Bye.
Okay. Bye.
Very good.